So I have an update in the California ammunition restriction and background check case Rohde versus Bonta, which recently was decided in favor of striking down those restrictions, but the state of California appealed up to the Ninth Circuit. So there's been some new developments that we need to break down. Now, really quick before we jump into this video, I want to thank the sponsor of this channel, which is 1st Phorm, and make you guys aware of a really cool giveaway that they're doing in partnership with Vortex. If you go to the 1st Phorm website down below, that's linked in the details section in the pinned comment, or just go to the link here on the screen, you can enter into the giveaway, and Vortex is going to be giving away about $25,000 in products and prizes, and then also 3 grand prize winners will be brought out to the Vortex headquarters, and then also you will get to train with the Vortex Pro staff. And on top of all of that, if you use my dedicated link down below and your order is actually over $50, you will get an automatic free 4-pack of energy drinks. So thank you to 1st Phorm for sponsoring the channel. Check out those links down below, enter to win that giveaway, and then also get your free energy drinks. Now, as I mentioned in the intro, in this video, we're gonna be talking about the California ammunition background check system, the ammunition restrictions that were recently struck down by Judge Benitez in the Rohde versus Bonta lawsuit. For the second time, Judge Benitez struck down those restrictions, and for the second time, the state of California has then appealed up to the Ninth Circuit, asking for the Ninth Circuit to uphold these bans. Now, one of the important things that is now developed in this lawsuit is the case is now tentatively set to be argued in front of the Ninth Circuit 3-judge panel during the month of December. So before the end of this year, the Rohde ammunition background check system case, that is going to be argued in front of the Ninth Circuit. Now, on top of that, the state of California is currently arguing that a recent assault weapon ban case, a decision out of the 4th Circuit, the Bianchi case, that now shows that the state of California can in fact place restrictions on ammunition, their purchase, acquisition, transfer, and including the importation restrictions that the state of California currently has in place. Now, if you're not aware, the case Rohde versus Bonta deals with the state of California's restrictions on the purchase of ammunition and also the background check system that you must go through to be able to purchase ammunition. So essentially, that's the law in question that's being challenged, and that was challenged in the Rohde versus Bonta case, and it went in front of Judge Roger T. Benitez, or Saint Benitez. And on original review, he found that this type of restriction is in fact unconstitutional. Now, after his ruling, the state of California then appealed that original decision up to the Ninth Circuit. But the ruling of that panel never went. They never issued it, because essentially what happened is they put the Rohde case on hold because the Supreme Court was set to rule in the case New York State Rifle and Pistol Association versus Bruen. And then what ended up happening is the Rohde case was then remanded back down to Judge Benitez for him to reconsider his decision in light of what the Supreme Court just said in Bruen. But of course, that really didn't make a ton of sense because Judge Benitez already applied his version of text as informed by relevant history and tradition. The decision by Judge Benitez lifted the background check requirement in California and then also lifted that importation restriction so people could once again go purchase online. California gun owners during that period went out and purchased ammunition online and just generally in California without the background checks. Now, in response to that, of course, California went back down to Judge Benitez. They asked him to issue a stay on his own decision, or in the alternative, to issue a 10-day administrative stay on his own decision so that they could appeal up to the Ninth Circuit. In that motion, California demanded that Judge Benitez respond by 2 p.m. that very same day, but Judge Benitez did not do that. I don't think that he liked being demanded by the state of California to respond within a certain period, but ultimately he denied the stay and then also denied the request for the 10-day administrative stay. In that decision, Judge Benitez stated that this court has given the state plenty of opportunity and time to provide analogs or other evidence to demonstrate the validity of its ammunition background check laws. The decision simply requires a return to the status quo ante litem as it existed prior to the effective dates of SB 1235 and Proposition 63. Having considered the relevant factors, and for many of the same reasons articulated in this court's order denying a stay of a preliminary injunction order, the request for a stay pending appeal and administrative stay is denied. So Judge Benitez denied those stays, and then the ball was in the hands of the state of California, and we knew they were going to appeal up to the Ninth Circuit, and so that's exactly what they did. They then appealed up to the Ninth Circuit and also went to the Ninth Circuit and asked for a stay. But during that period, there was a little bit of a lag from the Ninth Circuit. A lot of us thought that the Ninth Circuit panel there, the motions panel, would act pretty fast, but they didn't. And I think it was actually a whole weekend before the Ninth Circuit actually issued their order. I think it was the following Monday, we finally got an order from the Ninth Circuit. But because there was that lag, there were a ton of California residents who were able to purchase a ton of ammunition. So that was a small win. But like I mentioned, the Ninth Circuit finally issued their order, and they said that they were going to stay Judge Benitez's decision. And then they were going to take this up on appeal. But since then, there have been some additional briefs and amicus briefs that have been filed to the Ninth Circuit, moving this case towards an actual hearing. This month, we also received a notice from the Ninth Circuit that's handling this case that they intend to hold the oral arguments in this case before the end of this year, potentially in the month of December, but at the latest, if the attorneys' schedules don't line up, at the latest, probably early January. So the Ninth Circuit said that they're going to hear this Rody case probably in December. But another very interesting development has now happened in this case. And what has now happened is the state of California has submitted a supplemental authority letter to the Ninth Circuit arguing that the recent Maryland assault weapon ban decision in the Fourth Circuit Bianchi case, that supports upholding this California ammunition ban. In the letter, the state of California argues that appellants' right to notify this court of the Fourth Circuit en banc's decision in Bianchi versus Brown. The Fourth Circuit considered a Second Amendment challenge to a Maryland law banning assault weapons, after rejecting plaintiffs' facial challenge because plaintiffs failed to show that each firearms regulated by the Maryland statute is within the ambit of the Second Amendment. The court considered the constitutionality of Maryland's restrictions on AR-15s. The court applied Bruin's two-step methodology and concluded at the first step that the covered firearms are not within the scope of the constitutional right to keep and bear arms for self-defense. The court further held that even if the text of the Second Amendment were read to encompass the covered firearms, the statutory provisions would nonetheless be constitutional, because Maryland's ban on AR-15s is consistent with what they claim is a strong tradition of regulating excessively dangerous weapons once it becomes clear that they are enacting an inordinate toll on public safety and societal well-being, while nonetheless preserving avenues for armed self-defense. So California is trying to use the recent Bianchi improper military use analysis to essentially uphold this ammunition restriction. Also very interesting in this, what you can gather what California is currently arguing, is that as long as the state of California has some sort of avenue for self-defense, maybe some avenue to acquire ammunition, they can pretty much do whatever they want. As you know, even though they have a background check system, even though you can't purchase online or go out of state and purchase ammunition, the fact that you can purchase in some way ammunition in California, they say that that is good enough to meet the constitutional burden, to meet the Second Amendment's requirements, because you have some access to ammunition that you would need for self-defense. And they claim under Bianchi in Supreme Court precedent, that is good enough. In Bianchi, the Fourth Circuit en banc panel argued that in their belief, the AR-15 and similar rifles are useful in military service, and since they are militaristic weapons, a state can ban them as dangerous and unusual. Now, I'm not sure if California is going to make the same argument when it comes to ammunition, because potentially all ammunition could be used by the military, but not all ammunition is used by the military. So it's going to be interesting to see how they try to tie in that aspect of Bianchi into this case. Now, it's also important to note that Bianchi and its analysis is highly questionable, and it's in fact currently up for reversal in the Supreme Court. The plaintiffs in the Bianchi case are currently asking for the Supreme Court to review that and to ultimately reverse it. Also, it's funny if you look closely at the supplemental letter that was filed by the state of California, you can tell that California simply copy and pasted the same supplemental letter that they already submitted to the Ninth Circuit en banc panel in the Duncan magazine ban case. In fact, if you look at it, the state of California actually forgot to change the heading from the Duncan versus Bonta case to the Rody case. So it's just funny how, of course, California always copy and pastes all of their stuff from one case to another. We saw them file this type of authority in the Duncan case, and now they have filed it also in the Rody case. I think the Ninth Circuit panel here in the Rody case has already made up their mind, and keep in mind they've already placed a stay on Judge Benitez's decision, so they decided already at one aspect to side with the state of California and put a halt on that decision. However, I think it would be really good potentially for our side, because we are already anticipating that we're probably going to lose this anyways, that the Ninth Circuit probably would use the Bianchi decision to justify this ban. That would just further show the Supreme Court how all these lower courts are still engaging in active defiance against them. They are not using the appropriate analysis. They are relying on this military use analysis. They're still trying to backdoor in public interest. So that would go a long way once this makes its way up to the higher levels and potentially up to the Supreme Court. So that's what's going on. If anything else changes, I will let you guys know. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.